In today's day and age, electricity has become one of the basic necessities of our livelihood. With increasing focus on ensuring electricity for all and talk of reforms in the power distribution sector, the proposed amendments to the Electricity Bill 2014 has been in the limelight. Taking this into perspective, the need for amendments to the existing bill and its impending challenges was the focus of the workshop on Electricity Amendment Bill 2014 organized by IPPAI held in Kolkata recently. The opening address was delivered by Ashok Das Gupta, President, IPPAI.
What are the issues to be addressed? Now, we all know about the problems that we have been facing with regard to supply of coal. And we have gone for coal auction, bidding for the coal fields. And even those coal fields which were being mined, they were asked to stop. And perhaps it has taken us back. So the fuel availability is a big question. Although we have a capacity of more than 250,000 megawatts, what is our PLF? The PLF level hasn't increased. Then, of course, the mounting losses of the DISCOMs that we are all aware of, and that is not going to stop. Then we have transmission bottlenecks, stranded capacities. All these are the issues which are to be addressed now. Then open access. Open access has been discussed at various levels, various seminars which EPI have organized. Still, we have not come to any answer because the DISCOMs, they do suffer. And there are late, in order to give NOC, it takes a lot of time. Some of the gentlemen sitting here are fully aware of this. So open access really has not been applicable or made applicable so far. Then what is the impact on consumer? We all talk about this. I come back to my point on affordability. What is the effect on the consumers? Will they benefit or not? After all, this amendment of the bill is all meant to supply electricity to everybody and supply it at an affordable price. Will the consumer benefit?
Rajesh Agarwal, Chairman, Power Standing Committee, Bharat Chamber of Commerce, threw light on the proposed amendments to the Electricity Act.
The proposed bill aims to consolidate the earlier laws relating to generation, transmission, distribution, trading, and use of electricity, and generally for taking measures conducive to the development of the electricity industry, promoting competition therein, and protecting the interests of the ultimate consumers. Having been a bulk consumer and a stakeholder for long years, I would like to just touch upon a few important, innovative, and forward-looking proposals. The foremost among them, as Mr. Das Gupta had said, segregation of carriage from content. Ladies and gentlemen, this is the latest buzzword. To achieve the objectives of efficiency and for giving choice to consumers through competition, the concept of multiple supply licensees. Mind you, these supply licensees are completely separate entities compared to the DISCOMs of today. Regulatory mechanism. The bill has laid a lot of emphasis on strengthening the regulatory mechanism through various ways. Some of them can be A, service term, and this I believe is causing a lot of heartache to all the members of the regulatory commissions because the service term is supposed to be reduced from 5 years to 3 years. Penalties have been increased. Appellate tribunal is supposed to be set up so that all the cases of dispute don't get referred to the High Court. And one more very important thing is that in the regulatory commissions earlier, they had to compulsorily take the chairperson of either the CERC and the CEA as a member. Now they have to take the chairman of both the CEA and the CERC on the regulatory commissions. Before I conclude, I wish to once again congratulate the IPPAI for taking the initiative of gearing up a countrywide drive to gather opinion and suggestions to the Electricity Amendment Bill 2014. From the little that we have seen about the Honorable Minister, he appears to have hit the ground running to solve the problems of the interrelated sectors of power and coal.
Vishal Anand, Senior Associate, JSA Law, gave an overview on Electricity Amendment Bill 2014.
The basic problem which we are facing in this sector is actually on account of the distribution side, which most of the amendments and the Electricity Act fails to address. That is the major problem. when in 2003, the Electricity Act came, the total loss in this sector was 40,000 crore. Today, it has increased to 350,000 crore. Now, coming to the division of the carriage and supply. Now, one thing which everybody, there has to be seen that once it has been divided into carriage and supply, there is already a 350,000 crore of revenue gap in this sector. What will happen to that? Then there is a promotion of renewable energies. What we are facing today is the high cost of power generation. This is one thing which we have failed to address as of now, because in India, we are proposing to add capacity year after year. Because renewable energy, there is an initial cost is high, but subsequently, as we see, the cost of generation become very less because it's only the maintenance cost. So that is something which the government should look at and should promote more strongly rather than promoting other kind of generation business.
Following this, Shamal Sarkar, senior advocate, Calcutta High Court, spoke about the issues with the Electricity Act 2003.
Many provisions of the amendment, they are too vague, and I would say as high as opening my mouth too wide may be, that some provisions militates against the basic structure of Constitution. So if a licensee fails to maintain uninterrupted distributions, then reasons to be recorded, the license will be suspended, and then a proviso says they give a reasonable opportunity to make representation and consider the representation. And then subclause 4 says revoke the license. There's no provision of any show cause notice or opportunity of hearing or an adjudication. These are the issues. These are the issues one should address. And the language of law should be very clear. If they want that no hearing should be given, then it should be very clearly mentioned. And if they want that, since the Constitution mentions, say it is a quasi-judicial function, and for quasi-judicial function there are at least 150 cases saying there has to be personal hearing. Proposal is, wherever it says that the government in consultation with the regulatory commission, it can simply leave it to the regulatory commission. Why should government come in? Why should government come in at all? So long, from 2003, 2015, there has been no difficulty for the regulators. They have been performing perfectly, except somewhere, still some government interference, but again, unofficial, maybe there, but they are performing perfectly.
P.R. Ray, former chairman WBERC, focused on the challenges in the implementation of separation of carriage and content.
I think the first thing that comes up is separation of carriage and content. And this is something that has been discussed for the past 4 or 5 years. It has been implemented in various states. I understand it's a little intriguing to learn from Mr. Dasgupta suggested in the Mumbai conference that there should be a pilot. In fact, this is something that many people felt, that this is something that calls for a radical transformation of the power sector. The second thing I noted is that renewables, there have been a lot of discussion with renewables. Renewables never found a place in the Electricity Act. Now renewables find a place, so it becomes something that is statutory. About separation of carriage and content, we have to find some way. Whether we do it on a trial basis first and then extend it all over is a different issue. And bringing in renewables and making RGO and RPO, making that also statutory, that will be important. But unless these issues are taken care of, I think still we are in the midst of a jumble of words.
Satyajit Ganguly, MD ONGC Tripura Power Company, discussed the reality of open access in the Indian context.
The first type of open access customers are those who want to take power outside the host DISCOM because of commercial reason. That is, they get power from exchange or from other bilateral source at a cheaper rate. And the second type of consumers are those consumers who at any case are not getting supply from the host distribution company. And now the open access customers have also become very intelligent. So there are no open access customers. Actually, most of them are partial open access, where a consumer continues to have agreement with distribution companies and pay for the contract demand, and at the same time pay for alternative supply for the third party. And now if I see the exchange rate, say for eastern region, if I compare, yesterday it was less than 2 rupees 32 paisa RTC, and there was more than 2,000 megawatt available in the exchanges, and the power was not purchased. And when I open the NLDC website and see, India had more than 4,800 megawatt of load shedding. That shows that we have got power, but again, power at a price, and perhaps distribution companies don't purchase power or don't want to purchase power at a price which is even 250. And yes, I have seen the generators generating yesterday. We talk about merit order, but on that merit order, 50% of the generators should not have operated. What I mean to say is that if the cutoff power supply is at 2 rupees 40 paisa, then more than 50% of our generators' incremental cost was more than that. So it shows very clearly that we talk about merit order, but actually it doesn't happen. Lastly, I would say that right now, power sector is an inflection point, and all the stakeholders need to chalk out the way forward. What the denial of open access does is, you ensure that in certain places, the thermal power stations which are inefficient, they are generating at full blast, whereas in some places, generators are available, more efficient, they are not able to generate. So that's not merit order.
Prasun Basu Majumdar, Senior Consultant, Fox and Mandal, Kolkata, discussed various issues and challenges with open access.
What happened was that open access remained, and as speakers mentioned, really Bombay is one area where ultimately, at the end of the supply chain, there were four operators. But this is not because of the 2003 Act. They were there all along. Tata Power is a century-old organization. Reliance bought over the assets of BSES. BEST was there all along. The state players, of course, are always there. What happened in West Bengal was, after the 2003 Act, only which was always a part of the Act, that the State Electricity Board was divided into the distribution company and the transmission company. And only in Asansol, again, that was not a result of the 2003 Act, but there was more than one player. In Calcutta, you have the CESC, which has been there for ages. It was the first generating and supplying power. So where is this competition that we are thinking about? The competition concerns that we look at is ultimately, as a small consumer, do I really have a choice of more suppliers? Will this act really give me that? Will I be able to get a competitive rate? Again, we are really looking at larger consumers, but the Act places them at when we talk of bringing up a number of suppliers, we are looking at the small consumer. So my competition concern is, will it lead to a number of suppliers being available, and will it really lead to my getting the supply from the supplier whom I want? Because ultimately, there is a bottleneck. The bottleneck is the distributor. The distributor will have all the means that are available now, and unless a number of distributors are also available, open access is the only solution which can ensure that the suppliers get the power from other generators also.
A.N. Biswas, Joint Secretary, Department of Power and NCES, Government of West Bengal, focused on the independence and the role of state in the ambit of amended Act.
Electricity Regulatory Commission, it's the new provisions which are coming up that if it is vacant, it will be filled up. It's quite a good decision. And in our case, also, it is also a case that the chairperson appointment is taking a lot of time, because I cannot tell at this point of time what is the case, but provision said that there will be certain criteria that has to be met for selection of to that post, and it may sometime take a lot of time. And this is happening in our case. But if this provision is given into this amendment, it is provided, it will be obviously helpful. The problem still is there at this point of time that regarding this renewable energy is that thermal source, coal is quite abundantly available in and around our state. So when coal is available, then use of renewable energy takes a backseat. In the open access, the coal price have certain control. Can that be tagged with this biomass material? That can be explored, I think. And lastly, the solar panel, the PLF is around 17 to 18. Can that be increased to 20, 21, 25? This is the realm of research and development, and the country should try for development of such panels. This is highly required because such an availability of solar power is not very conducive at this point of time.
J. Mukherjee, MD, GP Green Energy Systems, threw light on the government's ambitious plans for the power sector.
Government has taken up ambitious program of generating 1 lakh megawatt of RE power by 2019. National Action Plan for Climate Change has taken a target of 15% of RE in the energy mix of India by 2020. Great. As a RE person, I am very happy. RPO is fulfilled today under 2 categories: non-solar, 3 to 10%, and solar, equivalent to somewhere around 0.25% in most states. Solar has been given a priority because when it was formulated, it was not that economically viable, but government wanted to promote that source of energy as well. Price band for REC for period April 12 to April 2017, non-solar 1,500 to 3,300, and for solar 9,300 to 13,400. So government has given a priority for and a special status for solar to promote renewable energy, green energy. RGO should be imposed on all municipal corporations. DISCOMs are why they are being burdened with RPOs. They are not the only pollution creators. The municipalities, it is their primary obligation to take care of the garbages. So they should be taken to the task. It should be their obligation as well to take care of it instead of doing politics on that. Like solar power, special treatment should be given for power from MSW by fixing preferential price band. Otherwise, projects will not be viable, private investors will not come into the play, and this is not going to happen.
The closing remark was made by Anup Singh, Associate Professor, Department of Industrial and Management Engineering, IIT Kanpur.
Electricity Act, Section 81 and Section 61 lays down that how much amount of energy which is consumed in the area of a distribution licensee that should be purchased by the obligated entities. The obligated entities itself was went into some legal wrangles at some point of time because of one missing comma. Had there been one comma, we could have a different obligation seen altogether. But coming from the economic efficiency perspective, the very first thing I always question is, are we really doing in the best way? Of course, we want to promote renewable energy. Is it possible that we can achieve it in more optimal fashion by spending less money so that consumers will have to be burdened less for the same good exercise of renewable energy? So I'll just question that. And the second thing is, which we have seen everybody talk about, is we have a missing RPO compliance. It's just not working. Why? Because first of all, these were most of them are publicly owned entities, and if they are private, there are questions about whether you can have penalty or not, the legal basis of that. I think it was mentioned in the morning also. We are not actually including in certain of our market instruments that I'll mention to you. I'll just give you this example of this particular side. So there was a solution. Is it possible to have a solution somewhere for these anomalies which we discussed? There were multiple number of suggestions which were handed over to REC, to CRC at that point of time, about how this can be done. So we currently have a REC market, we have a solar and non-solar, which itself is not required. As you are clear, if you break sugar market into two markets, a big grain and a small grain, there is of course a market for that. But you see that if there are two separate stock exchanges, there is a little impact. Of course, it's too big now on the liquidity. But on an REC market, which is just beginning to grow, if you have two market platforms, the liquidity goes down and the competition goes down. And that's the kind of mistake we have done. Market for green power, that probably should come at some point, but we are not saying anywhere that whether that kind of green power will get any additional incentive. People want to buy it. Yeah, this last point is also very important, is one of the reasons that REC market is facing, the two main reasons why REC market is facing challenges. One is, of course, the compliance not occurring at the distribution level, at the obligation entity level. And second reason is actually from the investment size. Your PPAs are bankable, but you don't have a PPA kind of thing in REC market. This suggestion I have also given a few times, that why can't we have a REC-based PPAs? You can always have, you can say, fine, the price will be determined for the market, no problem about that. But it's a queue-based PPA only quantity-based. I'll buy so many thousand megawatt hour of REC from you, price at whatever price occurs in the market. That is possible, and that will probably be much more bankable, I'm sure. And given that we have already a floor price, with which also I don't agree, it's pretty high. But whatever is a floor price, you will still have some bankability happening there.